Good afternoon and welcome to the public meeting of Randwick Local Planning Panel on the 11th of August 2022. Firstly, I'd like to acknowledge the traditional owners of the land and pay my respects to the elders past, present and emerging. I'm the chair of the panel and my name is Annalise Tour. Joining me today via video conference are Helen Lockhead and Oliver Klein as expert members, and the community representative is Peter Ryan. The panel has individually taken inspections of all the DAs on today's agenda from the street and surrounding area or electronically. We have been provided with an assessment report prepared by council staff who have also briefed the panel on each application. Today we have a number of people registered to address the panel. The order of speakers for each item will be firstly councillors, objectors, and then those supporting the application, including the applicant or their representative. Each speaker will be given 3 minutes. Any extension of time will be at my discretion as chair. The panel has been provided with copies of all the submissions received in response to the public exhibition of the application and forwarded a copy of late correspondence. Therefore, there is no need for speakers to repeat all the points made in those submissions or by previous speakers. Please focus on the key points you wish us to understand and consider. The applicant or their representative may wish to address issues raised in the council's report, including the response to conditions and any issues raised by objectors. We may ask questions of the speakers to clarify our understanding of what is being said. We expect that each speaker will be heard in silence while they are addressing the panel, and that courtesy and respect will be observed throughout this teleconference. I ask that everyone mutes their microphone unless they are called on to speak, noting that we have the ability to mute all attendees or individuals. After hearing from the speakers on all the items, the public meeting will be closed and the panel will then deliberate and make our decision. The minutes of the panel's decisions, including our reasons, will be available on Council's website as soon as possible after the public meeting. And you should be aware that the panel meetings are recorded and the audio recordings will be uploaded to Council's website. Each member of the panel has been asked prior to the meeting to advise whether they have a conflict of interest to declare in relation to any item on today's agenda, and I can confirm that no conflicts of interest have been declared. So the first item on today's agenda is a report in relation to delegations to the changes to the delegations in relation to appeals for the Randwick Local Planning Panel, and we have no speakers registered to speak on that matter. The next item is 77 Denning Street, South Coogee, and I'll just bring up the list of speakers. We have Jenny Askin on behalf of the objectors to speak.
Good afternoon, panel.
Good
Thank
afternoon.
you for the opportunity to address this afternoon. My name is Jenny Askin and I'm a town planner representing 79 Denning Street, the dwelling immediately adjoining to the south of the subject site. The amended plans before you do not alleviate the view loss objection, and I reiterate that there is still a view impact. Also, the assessment is not in line with the view assessment undertaken in the original DA. To obtain the original consent, amendments were made to protect the view corridor across the rear section of the dwelling at first floor level. This application now seeks to impact on this view corridor. The report assesses the impact as moderate, whereas the original assessment concluded that that impact was severe. Page 23 of the report states that a detailed assessment has been undertaken. However, there is no visual information relating to the amended proposal. On page 27, the report states it is estimated that the proposal as amended will retain views of Wedding Cake Island and the end of the headland from the rear balcony and from the most eastern area within the living room. The recommendation is based on an estimate, which is not reasonable in regard to highly valued views. I have submitted some of the photos to assist, and I maintain that the view of the headland, including the land-water interface and Wedding Cake Island, will be impacted by the parapet and the balustrade from these points. The parapet, as per the recommended condition, will be 250 millimetres higher than approved. The balustrade will be 1.05 metres higher than the parapet that was approved in this location. I note that the balustrade is to be glass. The glass can easily become obscured with salt air, and the provision of planting and furniture on the balcony can impede views. Tenacity principle refers to the reasonableness of a proposal. The application does not comply with height and FSR. The original DA was required to be lowered to meet the height standard and to protect this view corridor. The increase in height proposed goes against that and should also not be supported on these grounds. Tenacity requires the consideration of a more skillful design. The view issue, in my opinion, can be partly addressed by lowering the building. A reduction in height can easily be achieved given that the floor to ceiling heights are 3.1 metres at first floor level, 2.9 metres at ground level, and 3.3 metres at lower ground level. The thickness of the floor slabs can also be reduced. The applicant has proposed a balcony on top of a roof, which was set at a level to protect the view. Therefore, the balustrade of the balcony should not extend any higher than the approved parapet height of RL 52.15, and the parapet in the dwelling lowered accordingly. This reduction can easily be accommodated within the dwelling. We also request that the panel strongly consider this, noting that the original DA report confirmed that the ground floor balcony had access to iconic views. Therefore, a lower first floor balcony will also have access to these views. In addition, we request that the balcony be set in from the rear. Page 25 confirms that the balcony is a secondary area of private open space. A width of 2.7 and a length of 6.4 is still a very reasonably sized balcony, and a reduction in width to 2 metres is not unreasonable. This would set the balustrade back by 700 millimetres, reducing its impact on visual privacy and views. And just finally, I'd mention that our legal advice maintains that the modification is not substantially the same. The design is no longer based on large central courtyard spaces, and also there has been the issue in terms of the impact on the view across that roof. The essential elements of the development are not the same. The impacts are different, given the provision of living areas at the upper level as opposed to bedrooms as approved. I'm happy to answer any questions or clarify anything that the panel needs.
Any questions from panel members?
No. Ms. Askin, could you just repeat the, sorry, Annalise, Ms. Askin, could you please repeat the numbers that you stated with respect to the balustrade and parapet heights as approved? As
approved. So the approved parapet is at RL 52.15.
Thank you.
There's no approved balustrade because there was no balcony in this location.
Okay.
So what we're requesting is that the balustrade be no higher than the approved parapet of 52.15.
Okay, thank you.
Any other questions?
Well, I just want to clarify that as well. You said the parapet was 52.5, and then you said you don't want the parapet to be higher than 52.15. So which is it, 0.15 or 5?
0.15. So the approved parapet is 52.15. Okay. And what we're saying is that the balustrade, the proposed balustrade, should not be higher than this.
Okay. Thanks.
And you said that in your opinion, that can be achieved by lowering the floor to floor heights.
Yes. Yes, if you actually look on the section, you can see, so the floor to ceiling heights are 3.1, 2.9, 3.3. So that's floor to ceiling. And also there are slabs that are quite thick within the building. So any adjustment can easily be accommodated within the dwelling.
And in relation to the setback of the balcony, that's necessary even if you, in your opinion, even if you do that lowering, or is that an alternate to doing the lowering?
No, that's as well as, because we also have an issue in terms of visual privacy. So this would then offset the levels and then it'll be set back within the building. Also, if you look at the floor plan of the upper level, at the first floor level, they're actually enclosing those central courtyards. So they're getting quite a significant increase in terms of floor area. The balcony, potentially it could be left at the 2.7, but just set within the building. And then they would have that width, but if not, if they kept the glass line as proposed, they could have a width of 2 metres. It's been very clear in the report, and it's also been stated in the applicant's SEE, that this is not their main private open space, it's a secondary area, and therefore it doesn't need to be of this size. They've got their main private open space. They've also got a balcony at ground level that has access to views. But if it was set in and it was lowered, they would still see those iconic views.
Right, thank you.
Okay,
so,
thank you.
Yeah, on behalf of the applicant, we have Laura Reid.
Hello, my name's Laura Reid. I'm a planning consultant representing the owner of number 77 Denning Street. I'm actually here with Madeline Blanchfield, who's the architect, in case there are any questions. We've been working for a year and a half with council, having many discussions. We've amended plans twice. We erected height poles so that the assessment could be made by council of the view impacts. And we certainly recommend, welcome the recommendations in the planning report. There's just 2 conditions which we are concerned about, and I submitted a late submission yesterday. The first one relates to the condition 2A, the requirement for a 1.6 metre high sill height on an east-facing window. We did some view analysis to just demonstrate what impact that would have on the outlook from the kitchen and dining area. Obviously, the owner has bought that property to enjoy extensive ocean views from their main living areas, and to obscure it seems highly unfair, given that the neighbouring building at number 79 Denning Street has a north-facing window directly over our property, and all we're asking for is an east-facing window with an outlook to the sea. The second condition relates to the swimming pool. It's condition 2C. At no stage was this ever raised by council as an issue during the past 541 days that this application has been in with council, but they have imposed a condition. And so again, in our late submission, we have tried to address the issue by setting the pool back 3 metres from the Banksia, which is in the northeastern corner. We understand and accept a condition that may require an arborist report prior to a construction certificate, but we feel that it's not unreasonable to have a pool in the rear yard. Number 79 has a swimming pool, and the pool fencing will be the side and rear fence, which will be at 1.8 metres above existing ground level, not the height that's referred to in the report. I think that's the 2 main issues we've had, but I think we have worked tirelessly with council staff to get a proposal that is acceptable.
Thank you. Just in terms of the points raised on behalf of the objector, did you wish to comment on any of those, particularly the suggested amendments, why they are not reasonable, in your opinion?
I think that it is really largely an existing approval with some small changes. So to suggest dropping the whole building by a metre when it's already approved in its current form, give or take 200 millimetres, just seems pretty extreme. The balcony in question is so far under the height limit, it's uncovered. I think to not allow people that kind of amenity in their house is really unfair. And, you know, the whole issue is that a sideways view straight across our property. So understand Wedding Cake Island is iconic, but we've done all the analysis, put up the height poles. I just think the changes we're asking for are largely internal and to do with access for the owners, and to kind of go back and reassess the whole approved DA is not the task of council at this stage, I think.
My understanding of what was being said was that the parapet as approved was at 52.15, and what they were saying was that it be maintained at that level, essentially. So
yeah,
it's not changing. Like
ballast,
yes, sorry.
Sorry, the parapet has increased in height by about 200 mils, but I think the balustrade, which is a metre above floor level, is also in question. And, you know, if you want to get that balustrade under the existing parapet height, then that's, well, I don't see how that's possible.
Yes, but in terms of just what was approved, the balustrade wasn't there before, and the height of the of the parapet wasn't there before. So it's not just, you can't, in terms of what you're saying, well, you're changing the approval. Well, it's like as if that was approved. It's not approved. What is before us is those are the changes that we need to consider. So in terms of specifically what's put before us is how to deal with that, you're saying that would then result in further changes to the building which have been approved. Is that what you're saying? So I understand.
Well, I guess if it comes to the parapet could be lowered by 200 millimetres, wouldn't be extreme, but to not be able to use that space as a balcony. I don't know if you've got the plan there, but we have pulled back the glass line significantly from where it was approved. So most of the balcony, or I'd say more than a third of the balcony, is inboard to the building. It's not a big enough balcony to use as a living space. So to not afford the owners that additional space just seems, for the sake of the glass balustrade, which is beside a building, it's not in front of the neighbouring building.
It's very difficult because Lot 79 have a large balcony that overlooks our property, and you may not have seen that if you've only gone to the front of the property on a site visit. We're asking for a very modest first floor balcony of the living area, and number 79 also has their living area up on the first floor. I don't think it's not
okay. And sorry, just in terms of this swimming pool, just clarifying that, as I understand, there's a sewer line there, and therefore the swimming pool's above ground level. So in terms of the potential for privacy impacts, how does it work if your fence is 1.8 above existing ground level, but your swimming pool is above that? How high? What would be the relationship between the swimming pool fence and the swimming pool and the ability for people to look over into adjoining properties?
We covered this in the initial application, and the reason the deck is set to the house side of the pool is so that there's no standing space on the the wet edge of the pool essentially can't be stepped on. So you're in the water and up to your neck in water and not able to get up any higher. And I think Laura's point was that the outside of the pool would act as the fence. So there's no additional fence required. It's quite steep, that area, but I think the maximum is about 2.2 metres above natural ground.
Okay, and just in terms of building over the sewer, as long as you don't excavate, there's no constraints in doing that, or?
As long as, well, we don't need to build over it in this scenario, but it can be concrete encased if that is required, and as long as there's no inspection openings, there's no issue with that. That's very commonly done.
Okay, so when you say you're not building over it in this situation, on the plans it seemed as if the pool was over the top of it.
Sorry, I think with the current amendment, there's just a tiny little corner of it that goes over. Previously, we were building over it. Yeah.
Okay. All right. Panel members, have you got any questions? No? All right. Thank you. That concludes that matter. The next DA we have before us is the one for 22 Mears Avenue, Randwick, and we have Councillor Kathy Nielsen speaking.
Thank you very much, Chair. I acknowledge that the various amendments that have been made to the plans will make for a better dwelling for the applicant and will also reduce the impacts on the neighbours. I certainly agree that the important points listed on page 36 of the business paper are crucial for this outcome. I do have another suggestion for consideration by the panel. In order to address the amenity issues, particularly overlooking for the neighbour at number 22, I believe that this could be ameliorated if the balcony was further amended to be a Juliet balcony. And also in regard to the impacts from overlooking, could consideration be given to improve landscaping along the rear boundary fence adjoining the private open space of 4 Ada Street? They're my comments. Thank you, Chair.
Thank you. Any questions from panel members? No. And then we have Councillor Michael Olive.
Thank you very much, Chair. Some of my comments are going to echo Councillor Nielsen's, which is I think that the balcony extends too far. It concerns me that the heritage terraces, sort of which are outstanding, are being diminished in some way by bulk wrapping around them, and the balcony that's proposed extending further than the setback line of all of the balconies in the heritage area. And so I too would I think that sort of something like a Juliet balcony or a reduction in the size of the balcony which is proposed would be a good idea to maintain the values of that heritage area. Thank you.
Thank you. Any questions? No. Then we have Max Berghaus.
Thank you, Madam Chair. What I shall now speak about is just a summary of several submissions which are on the record papers within Council. Our property number 20, along with the other properties, terraces 2 to 20, are all heritage listed and protected. This protection, as well as imposing on us limitations, gave us, my wife and myself, sufficient guarantee to embark upon an historically informed and fastidious decoration of the interior and exterior of our house over a period of about 30 years, and also in conjunction with the National Trust. The Heritage Report commissioned by Council makes clear references to the deleterious effect in terms of heritage on the proposed development. It doesn't consider the rear of 22 nor the rear of our house. We submit, and this is in agreement with your two councillors, that there are other potential designs which would be less or possibly non-intrusive at all. 3, the proposed rear balcony destroys our privacy and amenity completely. It will also be orally very intrusive because this proposed development will be at a significantly lower level than most first floor additions as a result of 22 being at a much lower level than our home. The statement by Council's opposite that the effect on our privacy is lessened because the room behind the balcony is proposed to be a bedroom isn't true. The room could certainly be used for other purposes and might still be very noisy as a bedroom. Point 4, we reiterate that Council's consideration of the appropriate rear setback line is incorrect, pursuant to 3.3.3 Roman 2 of the DCP. The appropriate upper rear setback follows the northern front lip of the terrace's 222 verandas. The line is also set by 22 and its adjoining semi. The rear setback on the lower floor is separate from that on the upper floor. 5. We submit that a precedent stemming from the rejection by the RLPP on 15 July this year of development at 342 Arden Street beyond the existing upper rear setback line of the adjacent semi. The RLPP said, quote, "The minimum rear setback of the proposed first floor addition should be consistent with the adjoining semi-detached dwelling at 344 Arden Street, Coogee," close quote. Point 6. The Council's recommendation to reduce the balcony size and extend a privacy screen, so-called, which is dimensionally the same as the proposed extended balcony in the DA, is unaesthetic, and we question how it could be structurally supported. In any event, being a privacy screen, it's only 70% effective in protecting our visual privacy. Point 7. Our amenity will be overwhelmingly decreased if 22's proposed balcony plans proceed. We will not be able to use our backyard and pool in comfort due to the overlooking and unsightly balcony screen. 8. We would like our heritage item home at 20 Mears Avenue preserved for future generations as a model of Victorian architecture in Randwick with its associated curtilage. 9. Finally, we ask that the panel only approve 22's DA to the existing upper predominant rear setback line of the terraces and semis block. Thank you, Madam Chairman.
Thank you. Any questions from panel members? No? All right, thank you. The next speaker is Objector John Hearn.
Good afternoon. I'm John Hearn, a Professor of Medical Science from the University of Sydney and the University of New South Wales. My wife and I live at 10 Mears Avenue, Randwick, so I'm a neighbour of Max Berghaus and Lynn Wood at 20 Mears Avenue. I thank the Chair and Annalise Tui and committee for allowing me to speak. First, I endorse the comments from Max and Lynn. In addition, I'd like to make the following points that reflect the significant concerns that this development application has in the neighbourhood. There are 10 statements from neighbours that have been submitted. I would like to now make 3 points directly on the regulations and 3 on the outcomes of ignoring the regulations. First, heritage quality. There is significant lack of compliance in the application, affecting visibility from the street and clear offences against the heritage guidelines 1.12, 1.13, concerning development in the vicinity of heritage areas. Second, the Randwick Council rear setbacks regulations 3.3.3.2. There is blatant disregard for these regulations, which precedent can affect the neighbourhood. The setback limits are ignored. Thirdly, Randwick Council invasion of privacy regulation. The first floor rear balcony immediately overlooks the pool and property of number 20, causing permanent invasion and lifestyle damage. And fourthly, an outcome, the proposed sight screens, the addition of these is ugly and inadequate. They can also easily be removed or abused, either now or when number 22 is on sold later. Number 5, consultation. The lack of neighbourly consultation, other than a transient mention of the privacy screen by the owners of number 22, has already set up a potentially damaging and avoidable discord in the neighbourhood. And last, the recommendation for approval may open the probability of appeal and legal challenge now or in the medium-term future. So, Madam Chairman, in conclusion, this application makes major overall changes to the semi-detached cottage at 22 Mears Avenue. These are unsightly and abuse of the council heritage regulations, damage the quality of life of immediate neighbours, create precedent that may affect the rather unique heritage homes in the street and their value, and could bring the council into disrepute and subject to action. Thank you very much for your consideration.
Thank you. Any questions from panel members? No, thank you. And then on behalf of the applicant, we have Kate Burgess.
Sorry, I'm feeling very judged. Can you hear me? Can you hear me okay?
Yes. Yes, yes.
Okay. Firstly, I'd like to apologise to my fellow residents of Mears Avenue who are led to believe that we have plans to ruin the street. Far from it. Our intention is to restore this neglected little house so it can stand proud amongst the stately homes of our beautiful street. We've commenced the process with a comprehensive dam course, repairs to the roof, rust control and sealing the window surrounds to stem the existing water damage. It's over 12 months since we lodged our DA, so it's been carefully considered by Council and the heritage consultant. We believe the conclusions, after addressing the relevant concerns, are fair and reasonable in the main. We would ask that the panel consider 2 alterations to the conditions. Condition 2A, that the balustrade be retained in the original position. The purpose of the balcony is as an extension of the bedroom, which is quite small and with a very low ceiling. This was a concession to our neighbours at number 20. Instead of moving the first floor further north, as suggested by the heritage consultant, we lowered the roof. Slides provided by my architect demonstrate there's only a small difference in the view line of our proposal and the council recommendation. Based on figure 19, slide 3 shows the approximate view of the pool in our proposal, and slide 4 has overlaid the possible reduced viewing area if the balustrade is moved back. As a proportion of the back garden at number 20, it's quite minimal, but for us, the reduced amenity is considerable. I can assure Mr. Berghaus that his young granddaughter will not suffer any harm if we see her in the pool, as he insinuates in his objection. Figure 12 shows the palm trees growing on the boundary between our houses, which will also provide additional screening as they grow taller. As noted in the report, there's an extent of mutual cross viewing in the immediate area, where a few examples are shown in figures 14 to 18, and complete privacy between dwellings not achievable. Regarding privacy for the residents of number 4 Ada Street in their garden, figure 17 shows how much they're already overlooked by the many windows of the 3-storey flats behind them since the large tree was removed. So in fact, it's less likely that we will overhear their conversations from our balcony than we can now from our back garden when we're literally 2 metres away from them. Possibly we could see them if we were standing up, but they would certainly have more privacy in what they were saying. Condition 2B, obscured glazing is specified, but we feel that it wouldn't be sympathetic to our house or the surrounding properties. I wonder if the material used could be less specific so that we can select perhaps wood to match the cladding already being used or other suitable non-transparent material. Our adjoining neighbour in the semi at number 24, who will be most affected by the building process, has asked me to say today that she's in full support of our plans and looks forward to the improvement. Thank you.
Thank you. Any questions from panel members? No? Okay, so they're the speakers that have been registered to speak at this public meeting.
Sorry, sorry, yes. Chair. I did just have that comment about the internal layout of the.
Okay.
I was concerned about the bathroom and the study on the lower level in terms of the amenity of the study not having a openable window, so it becomes an internal room and therefore technically non-habitable. And I wondered whether you had considered changing the orientation of the bathroom from the horizontal to vertical so that it was long and narrow and access from the hallway, and extending the study nook off the living room, which would in turn make giving access to the windows expand the living area more generously, and it could be a nook or closed off if necessary as a study cupboard sort of nook. But it also would make it a habitable space, and you wouldn't actually need to walk through another room to get to the bathroom. It'd be directly off the hallway. Do you understand what I'm suggesting? Yeah.
Yes, thank you, Helen. We did consider that, but we really want to keep the outside of the building as original as possible. So if we were to do that, we would have to change the window, which is smack bang in the middle of that second bedroom currently. So if we were to put a small bathroom in there, we would have to change that window, and we don't want to alter the outside of that. And also the upper part of the wall in the study is going to have windows so that they will be able to be opened, and there's that bathroom window is the existing window, which is quite a large window, so there can be airflow through there.
Yeah, although technically that doesn't, I don't think it complies with BCA in that format. Have you checked that?
It is a study, not a bedroom, a non-habitable room. So we've provided a highlight window over the door to match the existing detail, interior detail.
Okay, well, it's your amenity, so
we want to keep as much of the original sitting room as we possibly can as it is, because that's quite original with the original fireplace and the windows. We're just trying to keep everything that's original that we possibly can and work around that.
Well, no, so that you actually are doing a lot of renovations, so so I just thought that might be an opportunity you could take advantage of, but it's up to you.
Thanks, Helen.
Thank you for the feedback.
So they are all our registered speakers. I know someone has their hand up, but you have to register to speak at the meeting. It's not something that we just allow people to do.
Excuse me, Chair. We had Ms. Wood presenting the slides for Mr. Berghaus, so she probably didn't get to present the slides, the photos.
Oh, okay. So that should have been done.
Are you there, Ms.
while
Wood?
Mr. Berghaus was.
Yes, Andrea, would you please show them, because unfortunately I'm not used to Teams and couldn't.
We've received the photos and forwarded them to the panel members yesterday, I believe. So I'll just quickly share the screen.
Yes, although we've had them.
They are the
so
full photos. Yes, that's correct. Yeah, everyone looked at them, but I'll quickly present them. Just 1 second. So this is photo 1. Photo number 2. And then we have a before photo and after photo.
Thank you, Andrea.
Thank you.
All right. Thank you very much. So that concludes the public meeting. And as I said in my opening, the panel meeting, the public part of it will now be closed, and the panel will meet to make our decision on each item on today's agenda, and our decisions and our reasons for decisions will be placed on Council's website as soon as possible. So thank you all for attending, and the public meeting is closed at 1:43. Thank you.
Thank you.
Thanks, Chair. Bye.
Thank you.